Major breaking news out of the United States Court of Appeals for the Ninth Circuit. The Ninth Circuit, a major win, believe it or not, out of the Ninth Circuit for the Second Amendment. A decision in Reno May versus Bonta, also known as Marco Calero, hope I got that right, versus Bonta, in a combined consolidated decision. They have basically decided that the injunction by District Court Judge Cormac Carney, which enjoined essentially all the quote-unquote sensitive places laws or government-mandated gun-free zone laws by Gavin Newsom, is to be enjoined, frozen, not enforced until this case is over. A major win. We're going to break it down and what it means when we get right back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and I'm proud to say a top 5 finalist in 2 separate categories for the 2024 Gundy Awards, top male influencer in the Second Amendment space, as well as top voices in the Second Amendment. Thank you for your support, and I'm honored by these nominations and by being a finalist in both categories. All right, this is huge news, and I've got some additional ideas I want to add to it. A lot of other people are covering this. It's breaking news all across the country. As you may recall, after NYSERPA versus Bruin was decided in the U.S. Supreme Court in 2022, a series of states, including California, went out and engaged in a series of hissy fits, angry and kicking and screaming about why allowing Americans to exercise their right to keep and bear arms under the Second Amendment, which is their right, was being enforced and imposed upon, if you will, as it should be, states like California and New York and New Jersey. So one of the things the state of California did is they went out and enacted a bunch of anti-gun laws in a hissy fit, angry, thumbing their nose at the U.S. Supreme Court's Bruin decision. And one of those laws was SB 2, which specifically says, with a whole list of things, that even if you've received a concealed carry permit from the state of California, you're still not permitted to bring guns in quote-unquote sensitive places, which, as you know, is a euphemism for government-mandated gun-free zones. There was a long list of, I think, something like over 20 different areas that you essentially could not bring guns in. This is clearly unconstitutional, and I was happy to report about a month or so ago that the United States District Court for the Central District of California, specifically Judge Cormac Carney, came out and issued an injunction that said that all of these quote-unquote sensitive places laws were unconstitutional under NYSERPA versus Bruin for a whole list of reasons. Specifically, there was simply no historical analog laws that would justify any of this. He went through a whole list explaining why the laws were unconstitutional, and I'm proud to say that one of the critical things that Judge Carney cited to and quoted was an article of mine, a scholarly article about the 18th century criminologist Cesar Beccaria, that says that when you ban guns or enforce gun control laws, you only hurt the law-abiding and not the criminal, because an unarmed man can more easily be attacked than an armed man. So a major decision by Judge Carney. It went to the Ninth Circuit Court of Appeals immediately. The state of California, Robert Bonta, immediately sought an administrative stay, or essentially an emergency stay, to prevent Judge Carney's injunction of the California law from going into effect. Essentially an administrative panel, which is like a temporary panel that serves for a month to deal with emergency cases, such as this one at the time, came out and said that they were going to grant the stay in favor of the state of California, which meant effectively that Judge Carney's decision in favor of the Second Amendment and against these gun control laws by Gavin Newsom, that law would be stayed, which meant that the injunction of these California gun control laws would no longer be effective, which meant, as a consequence, all of these sensitive places laws that Gavin Newsom had enacted would be enforceable. And if you were to bring a gun into a bar or these public gatherings or public transportation, a library, banks, whatnot, under these laws, you could be put in prison for violating the law and committing a crime. I'm happy to report, however, that late in the day on Saturday, the merits panel, meaning the 3-judge panel, that's going to actually hear the case in April when it's oral argument time. We don't know who these judges are, but the 3-judge merits panel took a look at this case and has dissolved the administrative stay by the emergency panel of the Ninth Circuit. The consequence, to make a long story short, is this: that the decision by Judge Carney that knocked out all of the sensitive place laws for all intents and purposes in California, the long list of them, I'll put a link to Judge Carney's opinion down below to remind you what was covered. That order enjoining those sensitive place laws against gun owners is now enjoined again. The order is back in effect, which is a major win for the Second Amendment. Now, what's interesting here, of course, is that this is going to mess up California terribly, as well it should, because Californians have a right to keep and bear arms and should be able to carry guns all across the state for self-protection, just like people get to do elsewhere in the United States. What's interesting is that the merits panel, and there's a footnote in this order, by the way, that says that 2 of the 3 judges on the merits panel issued this order dissolving the administrative stay, which meant effectively that the Judge Carney favorable 2A decision went into effect. 2 of the 3 judges agreed, and the 3rd judge, whoever that 3rd judge is on the merits panel, was unavailable. So we don't know whether or not ultimately, when the case is heard, assuming that the judges go this way after they hear the arguments, whether it will be 2-1 or 3-0, because we don't know. We only know that 2 of the 3 judges agreed that this stay should be dissolved and the Judge Carney's decision should go into effect and the laws of California should be enjoined against the Second Amendment. That's all we know. We don't know who the panel is. I tried to figure this out. I just simply don't know who it is yet. I'm going to see if I can do some snooping around and try to intuit who it may be. Right now, we don't know. Now, what's really shocking here, and this is what I just want to leave you with, is this. You know, in a lot of these jurisdictions where, for example, in Illinois and in Maryland, where the courts allow these gun control laws to go into effect, and then there's an appeal up to these courts of appeals, and these courts of appeals, like the Fourth Circuit Court of Appeals in Maryland and Virginia, or maybe the Seventh Circuit Court of Appeals in Illinois, or maybe even the Ninth Circuit Court of Appeals in certain situations, when the lower court is allowing these gun control laws to go into effect, or these gun control laws are still effective, it's very interesting how a lot of these anti-gun courts sit on their hands and take an extremely long time to issue a decision, because every day they do not issue a decision is another day those gun control laws remain in effect, right? What's interesting here is the dynamic is now going to be reversed, because right now, Judge Carney's injunction of all these various sensitive place laws is the law of California, which means until a California Court of Appeals, meaning until the Ninth Circuit Court of Appeals were to, assuming this were to ever occur, were to issue an anti-Second Amendment ruling reversing the decision by Judge Carney, until that were to occur, Judge Carney's injunction of these laws will be the law of the state of California, which means Californians with CCWs will be able to carry into these otherwise prohibited places, which means, strangely enough, the incentive, as I see it, I mean, I can think more about this, maybe you'll disagree, you'll let me know, but it seems to me at first blush, the incentive for a panel, if they're friendly to the Second Amendment, this is going to be a little counterintuitive here, is perhaps to hear this argument in April and sit on this case for 18 months or 2 years, because as they're sitting on the case, interestingly enough, they're allowing the decision of Judge Carney to remain the law of the land, and therefore, as a consequence of this, just thinking out loud here, that would prevent the Ninth Circuit Court of Appeals from en banking the panel decision, because there is no panel decision to en banc, and every day the panel is waiting to issue a decision on the Second Amendment is another day that Judge Carney's decision is in effect, which means it's another day that Californians will be able to carry their guns in these otherwise prohibited places under California law. So in this case right now, it's kind of the reverse, where a long time delay in issuing a Second Amendment ruling by a panel may actually be to the benefit of California gun owners. We can have that debate down the road, but that is just something to keep in mind. Now, just as a quick reminder, the decisions in some of the sensitive places that were prohibited, you could not bring a gun as of January 1st under the laws, but now it looks like you can because of Judge Carney's decision going back into effect. Those are places of public transportation, bars or places that serve alcohol. public gatherings where people, got together, playgrounds, parks, athletic facilities, casinos, stadiums, amusement parks, some of these places, libraries, places of worship, banks. There's this no carry default rule that says that unless you get permission with a permission slip or a sign in the window, you're not allowed to carry guns there. Even if you're allowed to, like you go into a gas station, it has no sign, you couldn't carry a gun there under the default no carry provisions. That was knocked out. That's not the law. And of course, parking areas as well. Now, none of these places should be sensitive places because none of them offer comprehensive security. None of them offer armed guards. None of them offer metal detectors. So none of these things are analogous to the three places at the time of the founding that are sensitive. That would be polling places, legislative assemblies like Congress, or courthouses, all of which were protected by men with guns, comprehensive security either in the form of bailiffs, sergeants at arms, or sheriffs or their deputies. So the bottom line is that Judge Carney reached the absolutely correct decision. I'm happy to see that two of this three-judge panel on the merits seems to be going in the same way that Judge Carney ruled. That's very favorable. And again, I think the oral argument is in April. So Californians, congratulations. This is a great New Year's / Christmas gift for you. It's not a gift. It's really your fundamental right, but it's great to see that at least some judges in the United States Court of Appeals for the Ninth Circuit respect the Second Amendment and are going to enforce it the way they should, the way it's written into our Constitution. This is a major battle, a major success. Obviously, the war will continue in California and beyond, and we're going to be here for all that here at the Four Boxes Diner. So there you have it. Again, if you haven't subscribed, please do so. Feel free to share this video. Follow me on Twitter or X at Four Boxes Diner, and we will see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.